We all know the sort. The guy who smiles at you cordially every time you see him in the street, but drops his entire garbage bin in front of your house every single day, or the young man next door who has decided that 1 a.m. is a great time for him to sing along to rock music. Or how about the old man who refuses to prune his massive tree that hangs over half of your land despite request after request after request? We all have a neighbor who seems to be straight out of Hades, but the question is, what can we do but suffer? When living in society, it is almost inevitable that you will have to come into contact with people who will leave you profoundly irritated, frustrated, and/or disgusted, and in most cases, you have to shut up and take it. But the house is your one true refuge where you can hide away from the rest of the world and, for a few precious hours, not have to worry about your miserable existence. Unfortunately, the fact of communal living is that often even this safe sanctuary is breached by the gaggle of obnoxious wastes of biomass we call our dear neighbors. Whether they mean well or not, it is undeniable that they can make your life at home absolutely intolerable sometimes. Fortunately, the law provides ways to deal with such intrusions. Let's find out what to do when you're stuck with your own little house side issue using a few illustrative situations. Before we begin, be sure to hit that like button. Don't forget to subscribe to the channel and press that bell icon to stay updated with the latest news from Amicus Curiae. Step 0. Is it even worth it? No, really. Give it a nice, long thought. The law may be slow sometimes, but it is a very powerful and, frankly, hostile weapon. Litigation is something that is adopted when any amicable resolution is no longer possible, and even in the most legally inexperienced societies, this simple inference is understood. Like it or not, your neighbors are people you will have to interact with a lot and spend a significant portion of your time with. Additionally, it is very rare that a dispute arises out of actual malice rather than a simple misunderstanding or oversight. Legal remedies should ideally be the last resort in dispute resolution. If possible, settling the dispute amicably is faster, cheaper, and makes you far more likely to part on friendly terms. Thus, the first course of action is simple: talk. Talk to the neighbor that is bothering you, lay out your issues, and suggest a solution that will ideally satisfy the interests of both sides. Do not be greedy, and do not threaten any legal or other forms of action. Both parties must meet midway and arrive at a friendly settlement. 90% of all disputes are caused due to a lack of communication and can be resolved simply and speedily in this way. Step 1. Analyze and prepare. If an amicable resolution cannot be achieved, it is time to make war. But as the saying goes, amateurs study tactics and professionals study logistics. The first step to effectively fighting is gathering supplies and ammunition. Begin documenting all the issues caused by your neighbor by writing down details in a journal or document. Collect evidence through photos, videos, witnesses, or any other method that may seem appropriate. Above all, consult and retain an advocate if you seriously intend to follow through with a legal option. The advice and guidance of a legal professional are not just important at trial, but at every step of the process, whether it is dealing with the police, filing the correct documents, or advising on the correct course of action. The facts of every case can vary wildly, and a generalized video on YouTube can only cover so much information. For case-specific advice, always refer to your lawyer. Step 2. Throw down the gauntlet. Once you're as ready as you can be, it's time to issue the declaration of conflict. Usually, this is done by issuing a formal legal notice through your advocate, informing the person who has wronged you, in this case, your neighbor, of their infractions and asking them to cease the activity in the future on pain of criminal or civil penalty. The notice may also ask for redressal of previous wrongs through monetary compensation or other means. Unless you are filing a suit against the government or any public officer, sending a notice is not mandatory in most cases, but it is considered proper form to make your opponent aware of your intention to pursue legal action beforehand rather than directly filing a case out of left field. Additionally, it provides a final chance for the other party to comply with the threat of legal action. This is that much more important in India, where people are inherently scared of litigation and legal process due to its perceived slowness. Here, the mere threat of having to appear in the court may convince your neighbor to abandon his previous ways and leave you in peace. The traditional method of sending a legal notice is through registered post, with acknowledgement receipt to prove that the other party has received the communication. However, today courts have started to recognize notices sent by email or even instant messaging platforms like WhatsApp or Telegram as valid. Step 3. Fight. If your neighbor refuses to back down, now it's time to lawyer up and paint the town black with legal ink. There are plenty of scenarios that can fall under the broad category of harassment by a neighbor, so let's try to cover a few representative scenarios. Scenario 1, noise complaint. Imagine this: you have had a long, painful day at work. Maybe your boss yelled at you for missing an impossible deadline, or someone scratched your car on the way back home. You stagger in at 11 p.m. and somehow manage to make it to the bed before collapsing, ready for a long, nice nap. Then, you hear it. Someone next door is blaring music from their sound system, as loud as it can go, while singing along in possibly the worst voice you have ever heard. You have talked to them maybe 30 or 40 times, asking them to at least restrain their shenanigans to normal waking hours, to no avail. Your teeth are rattling within your skull as the bass sends shudders through your walls, and you want nothing more than to grab a knife, march over, and slit both the music player's power cord and your neighbor's throat. Somehow, you control your homicidal tendencies. Now what? What you have just experienced is noise pollution, and it isn't just a case of preference. Loud music and other noises at odd hours can have actually detrimental effects on your health by disrupting your sleep cycle and increasing stress levels. Luckily, the government of India caught on pretty quickly to this fact and notified the Noise Pollution, Regulation and Control rules under the Environment Protection Act in 2000, regulating the use of all noise-producing equipment like music systems, firecrackers, generator sets, and even vocals. Depending on the area you live in, there are different daytime and nighttime noise limits prescribed, and it is the government's responsibility to enforce them. For most of us, the area we live in would be classified as a residential area, which has a day and night sound limit of mean 55 and 45 decibels on the frequency scale of human hearing. This measurement is expressed in units as dB, A, lec. Day denotes the time from 6 a.m. to 10 p.m., and night means the time from 10 p.m. to 6 a.m., basically the rest of the day. According to the rules, it is forbidden to use any sound amplifier or musical instrument or any other sound-producing instrument or loudspeaker at night, except in cases of public emergency or for internal communication in private places, such as PA systems in theaters or halls. At any other time, a person is free to play his music as loud as he wants, but only inside the house. At no point should the noise level beyond the private premises go more than 5 decibels above the limit. A loudspeaker can only be used with written permission from the government, and the noise should not go more than 10 decibels above the noise limit or above 75 decibels, whichever is lower. Violating these rules is an offence under the Environment Protection Act and can attract a fine of up to 1 lakh rupees and imprisonment for a term up to 5 years on the first offence. However, to initiate proceedings, 60 days of written notice must be given to the State Pollution Control Board or, in the case of a union territory, the Central Pollution Control Board, in the format of Form 4, under the Environment Protection Rules, 1986 by registered post. For more immediate relief, just pick up your phone and call the police. As per Rule 8 of the Noise Pollution Regulations, the government can act on information received via a police officer and take any steps necessary to end any annoyance and disturbance caused by noise, including that of a vocal variety. The police will first warn the noisemaker to stop, and then fine him and seize the sound-producing equipment as necessary. In 2020, the National Green Tribunal approved a revamped set of fines proposed by the Central Pollution Control Board between 1,000 and 1 lakh rupees under the polluter pays principle, separate from the offence under the Environment Protection Act. Thus, the government can now directly seize equipment or impose fines without having to go through the arduous procedure followed previously. Scenario 2, the garbage dumper. The moment you step foot out of your house, your foot makes contact with something warm and slippery. You look down, a banana peel, and just like that, you know there is another mountain of trash waiting for you just outside your gate. Of course, the healthy young man in the house beside yours cannot bear to walk the 2 minutes to the communal garbage bin, and so he has decided that tossing it over the wall into your compound or dumping it on the driveway is a perfectly reasonable option. What should you do? The remedy will vary on whether the dumping is done on your private land or in a public place such as the street outside. Criminally, Indian law only recognizes public nuisance is actionable under Section 268 of the IPC. If your neighbor dumps garbage in any public place that causes annoyance or obstruction to the people in the vicinity, you can call the police and inform them of the same. However, since it is a non-cognizable offense, they cannot register an FIR for it. What they can do, however, is approach the executive magistrate under Section 133 of the CR. PC. Under this section, the magistrate can serve a conditional order on the person who has created an unlawful obstruction in the public place to clear it. If the person does not do so and also does not appear before the magistrate within the stipulated period to respond to the notice, they may be punished under Section 188 of the IPC for disobeying the order of a public officer. If you file a complaint under Section 268, the person may also be punished with an additional fine of up to 200 rupees upon conviction. In case the waste is dumped directly onto your private land, you can proceed against them under Section 425 of the IPC for causing mischief, as waste damages and diminishes the utility of your property. Depending on the damage caused, mischief with garbage can attract up to 2 years of imprisonment and a proportionate fine. If you own any pets or cattle that are killed or maimed because of the waste, the one responsible can even be imprisoned for 5 years. You can also file a civil suit against them for private nuisance and trespass to land and/or goods, asking for damages and a prohibitory injunction forbidding the other party from dumping any such waste on your land in the future. The direct physical interference and damage of dumping garbage or other waste are considered under trespass, while other considerations like visual pollution and noxious fumes are incorporeal and fall under nuisance. Regardless of the private or public nature, some acts are criminal by virtue of what exactly is being dumped. For example, dumping decaying biowaste that can breed disease-carrying insects is considered an offense under Section 269 or 270 of the IPC and can attract imprisonment of up to 2 years. If the garbage washes into and fouls a public water reservoir, it may be an offense under Section 277 and the accused may be fined 500 rupees and be jailed for 3 months. Noxious, poisonous, combustible, or explosive substances, if negligently disposed of, can similarly attract punishment. Scenario 3. The interference specialist. The moment you look away, he's at it again. He blocks your drain. He sets up tall walls. He parks his car right in front of your door. All in all, he has made it his life's mission to make your life as miserable as possible. What can you do? Every property in existence comes with some unspoken rights relating to its use. For example, if the only way to get to land you own is through a path that falls on someone else's property, it is understood that you have a right to go on that land. Or, if a house has been draining its rainwater into a field for years now, it seems fair to say that they have acquired a right to continue doing so in the future. Such an unspoken right attached to a movable property is known as an easement. Easements can be divided into many types, such as easements of necessity, quasi-easements, prescriptive easements, or express grants. An express grant is an easement that is written directly into a contract or deed while the property is transferred. However, what we are really concerned with here is the category of implied easements. The basic difference between an easement of necessity and a quasi-easement is that the former is absolutely necessary to enjoy the property, while the latter is for enjoying the property in the same way as it was enjoyed before the transfer. Thus, a right-of-way absolutely necessary to access the land is an easement of necessity, while a right to the light and air from a window that was unobstructed during the transfer of the property is a quasi-easement. Both types of easements come into being during the transfer of the property and exist only between the transferor and the transferee. Thus, if your neighbor is your landlord or the person who sold you the property, you are entitled to enforce whatever benefits the land may have come with at the time you bought or leased it, should they attempt to block it. On the other hand, an easement by prescription is a function of the land itself, independent from who owns it, and comes into existence with the passage of time rather than at the time of transfer. Generally, if an easement is enjoyed in an uninterrupted fashion for more than 20 years, the land acquires it by prescription as an absolute right. This includes things like right-of-way, right to light and air, right to support, and right to discharge rainwater or sewage. Thus, once an easement has been established in this way, the person whose land is being used cannot at a later date deprive you of it by, for example, blocking the path or building in such a way as to substantially obstruct the light and air received by your property. If such an attempt is made, you can file a suit and get an injunction restraining your neighbor from obstructing your easement. In case you have suffered some damage from their obstruction, you can sue on the grounds of disturbance of easement and recover proportionate damages. You cannot remove the willful obstruction yourself. However, you can take such action as is necessary to keep your easement open against an inadvertent obstruction. For example, if your neighbor's tree is growing too big and impeding the access of light into your house, you can enforce your easement by pruning the branches. However, you cannot cut down the tree entirely as this would cause unreasonable damage and inconvenience to them. The law of easements in India is governed by the Indian Easements Act, 1882. These were a few probable scenarios involving annoying neighbors and how you can deal with them. Court cases in India can drag on for a while, but the good news is that all civil disputes can be settled out of court, and most criminal offenses against property are compoundable. As long as you have a solid case, you might be able to convince the other party to settle with you out of court in exchange for monetary compensation or a guarantee to not repeat their behaviors and redress any previous wrongs. If this succeeds, you can walk away with a potentially hefty sum in relatively little time. Thus, the law is an incredibly powerful tool that can help you in many ways in your day-to-day lives, if only you know how to use it. Do you now feel that you are equipped sufficiently to deal with the Karen next door? Let us know in the comments. As always, if you liked this video, be sure to like it, and if you wish to keep watching informative, concise, and fun explainers like this one, press that subscribe button and hit the bell icon. This was Amicus Curiae, and thanks for watching.